Hello, I'm Walter Haines with United Employees Law Group. This message is one of a series designed to expose common errors and violations engaged in by companies that have shortchanged employees out of tens or even hundreds of thousands of dollars in overtime pay and related violations. Having prosecuted well over 700 labor cases, of which more than 70 were class actions against Fortune 500 companies, we discovered that most of these errors and abuses went unchecked over time because employees counted on their employers or the government to protect them. Unfortunately, this has allowed some employees to suffer major losses. We at United Employees Law Group have created this series to help you recognize some of the common violations we've prosecuted. This series is designed to give you insight on your employment rights. The following discussion covers the professional exemption, which in many instances has been used improperly to deny overtime. The professional exemption generally applies to two major types of employees. The first type is comprised of individuals who maintain licenses by the state of California and are primarily engaged in the practice of law, medicine, dentistry, optometry, agriculture, engineering, teaching, or accounting. Note that pharmacists and most nurses expressly are excluded from this exemption and therefore may be entitled to overtime compensation unless he or she falls under another exemption. Employers sometimes make the mistake of classifying as exempt those employees who have not yet received their licenses. In addition, with the exemption of certain high-level computer professionals, employees that are paid hourly rather than a salary are misclassified as exempt under the professional exemption, even if they satisfy the duties test. The second type of employee who may be covered under the professional exemption are those engaged in learned or artistic profession. Duties are more than 50% of the time in that area. Specifically, the learned or artistic professional exemption requires knowledge of an advanced type of field or science or some kind of specialized intellectual type of study that is different than a normal academic education or apprenticeship. Employees no longer are required to have post-bachelor's degrees from college. However, the degree must be in the field of science or learning, and it must be required by the employee's position in the company. The learned and artistic professional exemption also includes work that is original and creative in character in a recognized artistic field. Work that relies primarily on invention, imagination, or talent of the employee and something that cannot be duplicated or standardized. Because of the complexities and subtleties of the administrative exemption, it is difficult for an employee to know if his or her employer is applying the law correctly. The key here is to know when to seek an unbiased analysis of your situation. If you suspect you've been misclassified, take a couple of minutes to talk to an experienced California labor law attorney and find out what your rights are. This video is part of United Employees Law Group's effort to provide useful information and strategies to protect your rights and to level the playing field. Thank you, and I invite your comments.